over 7 years of trying and failing, Kenya finally has a data protection law. It provides new ways for consumers to hold companies accountable in how they use their information. Firms must now be clear on why they are gathering data, how they will use it, and when they will delete it. Now, this is especially important because of the explosive growth in mobile commerce and mobile money. In the 3 months to end June, Kenya had over $21 billion in peer-to-peer mobile money transfers and another $19 billion in mobile commerce transactions. And to enforce these provisions and others, a data commission will be set up. That body will have the responsibility of setting up regulations on matters like when data must be stored locally, as well as investigating complaints on how data has been mishandled. If this sounds a lot like the EU's general data protection regulations, well, that's because it was partially informed by EU laws. Now, earlier, CGTN's Ramanyang explored what this new law would change for consumers, tech and financial services companies in East Africa.
It's a personal philosophy, if you will. So the United States has gone down the road you've described, where they have not legislated in a heavy-handed way, whereas Europe has definitely gone the other direction and said, look, this data is valuable. It's something that people don't necessarily have very much control over, and we cannot let companies and other entities just do whatever they wish with that data, hoping that they have the best interest in mind of the data subjects. Instead, we're going to let the government, particularly the data commissioner in this case, look out for the best interests of the individual.
One of in earlier drafts, I remember one of the debates around this was how free, how independent that data commissioner will actually be relative to the executive. To what extent are they independent? Are they free of any interference from whatever the political power of the day might be? Yeah,
so this particular law did go down in the direction of a more independent data protection officer. So there was a lot of debate about whether it should be someone within a ministry or an independent office. It ended up being a state office. And so the data commissioner will be nominated by the Public Service Commission, appointed then by that nomination will go to the president for appointment, but then budget will come from Parliament. It should be pretty independent.
All of this boils down to how well it's implemented, doesn't it? Because on paper it looks very interesting, very sweeping, very comprehensive, but it does essentially come down to how well it's enforced.
Absolutely, and enforced, and more than that even, a lot of the provisions remain unclear or up to the discretion of the data commissioner. So a lot of this we can't yet say, will it be effective? We'll just have to wait and see how, the data commissioner is, if that person is, that person's philosophy will actually influence a lot about how this acts.
So, for example, that data localization issue that we spoke about, because this does not, by default, tell companies that you must host data for clients in Kenya within Kenya's geographical boundaries, does it?
That's correct. It does give the data commissioner the authority to say certain things need to be done in Kenya, but that's not the default position.
Microlending, that's one sector that's been growing relatively fast, especially after September 2016 when the rate caps came into effect. And one of the criticisms leveled against the industry is that they just hoover up enormous amounts of information. They're not clear about what they're collecting, why they're collecting it, where it's stored, how it's used, etc., etc. For those guys, how does this change their market environment?
Potentially in several different ways. So first of all, you are, of course, if you're collecting data, you need the consent of the individual data subject. You need to tell that data subject what you are going to be doing with their data. And if you decide to do something else later, you have to go back and get their consent for that new thing. The other thing that might change, interestingly, is that this law says you cannot make automated decisions, such as loan application decisions, completely in an automated fashion. So one of the hot things right now is AI being applied to loans, credit scoring, alternative credit scoring, that sort of thing. You cannot make those decisions completely automated any longer.
That's interesting. Why? What is the rationale for that?
Well, the rationale for that is that we still want a human to be involved at some point in the decision making, because we cannot distill, essentially we're saying we cannot distill a human being into just a bunch of numbers.
Lines of code.
Or lines of code, exactly.
Yeah.
So we need that ability to say, wait, this person we know, maybe they don't have the best credit, but they have a bunch of references, they have whatever else we've seen, and we are going to take a chance on them. Only humans really can do that at this point.
And in any case, it also, part of the other reasons for that probably be the fact that a lot of these algorithms are essentially black boxes. You put in data on one end, you get a result, but you don't know how the result is arrived at.
Very much the case. And also some of these algorithms are written by Western companies, essentially. So we don't, you know, the issue of bias that creeps into these algorithms is something that's everybody is struggling with right now, and it will definitely be a problem here as well. So this is meant to make sure that the bias, even with algorithms, the bias is minimized, or at least that we have a way to say, well, it wasn't just the algorithm, right?